Oh, thank you very much, Tarun. I'm going to ask our other panelists, Schona Jolly or Dumiso Gatsha, is there anything you want to add to that around the benefits of comprehensive equality legislation or its content and scope?
Evelyn, thank you. Tarun, thank you. That was really interesting and informative. And I come at this from the perspective of a practitioner. I've been working in equality law in the UK and internationally for more than 20 years. And in that timeframe, we've had the Equality Act, which is a comprehensive piece of legislation introduced in the UK. So we've moved from the single issue pieces of legislation, single issue commissions dealing with those at a national level, to this comprehensive form of equality law. And I know when shortly I'll come to talk about the sort of pros and cons of that law, but I think there's no doubt that what it has brought is a shift in the narrative that Tarun is talking about. So you actually, previously I would be instructed to look at something from a sex perspective only or from a race perspective only. And I think the sort of harmonizing of that is incredibly important, not just for individual groups, but in recognizing the intersectionality. Now, it's another question whether our Equality Act actually does that. But I think it brings together the concept of discrimination as a sort of fundamental right. So it's not just sex and it's not just race or just disability, but there is now actually a sort of fundamental understanding of discrimination or equality at some level as a fundamental right. And I think that has been a real benefit of it. And you see that, for example, reflected in the fact that there is a single issue Equality and Human Rights Commission. So it's not just sex discrimination or age discrimination, but all forms of discrimination are then actually categorized within a broader category for human rights. And I think just at a fundamental level, that's a very important shaping of the narrative. And I think it gives an understanding sort of from top to bottom, from the most disadvantaged society to the most advantaged in society in terms of a framework and narrative of thinking about it.
Thank you, Evelyn, and thank you to the panelists and everyone participating for helping us launch this publication today. We are very proud of it and very proud to share it with you all. Part 3 of this publication has case studies from South Africa, from Canada, Buenos Aires in Argentina, Moldova, and Great Britain. And it looks at the implementation of comprehensive equality legislation and the use of such legislation from courts and equality bodies to extend protections to groups that may not be explicitly covered, to provide remedies to victims of discrimination, and to promote the advancement of equality of opportunity among public authorities. My question for Schona is on how we can use equality legislation, comprehensive equality legislation, to advance substantive equality, and whether we're there yet in the UK, and if not, how far do we have to go, and what steps we should take?
Thank you very much. Thank you, Ariane, for the question, and to the Equal Rights Trust for welcoming me onto this panel. And as always, I support Equal Rights Trust in their incredibly innovative and important work. So thank you very much for that. Ariane, as to the first question about comprehensive equality laws, in some way, I feel that Tarun has probably touched on that ground. And I think perhaps all I really want to say is that what they can do is create the societal narrative that flows from top to bottom and bottom to top, vice versa, permeating, I think, views across a period of time and hopefully seeking to build on each platform that's come before it. So, for example, in the UK, what you see is that actually we've had sort of a multi-generational approach to equality laws. It started really with very, very formal race equality laws in sort of about 50 years ago or so, and that was slowly built upon, and then sex discrimination laws and equal pay laws were introduced at around about the time that we entered into the EU. And then the EU's progress in equality law over time has been a sort of steady building from a very formal economic approach, equal pay, equal rights, sex-based rights, to an approach that somewhere sits between formal and substantive equality. And it's had sort of some forays into substantive equality, for example, with indirect discrimination, and also with its sort of attempts in the 2000s to try to branch out into a wider number of protected characteristics. So starting from sex and race, and we in the 90s also had disability discrimination introduced in 1995 separately, which was a very, very big deal when it came into effect. It was new, it was different, it was modeling a very substantive form of equality through, for example, the test of reasonable adjustments, reasonable accommodation, which is not something that we'd had in this country before. And then in the 2000s, you saw the EU introduce specific regulations in the employment field relating to age, relating to sexual orientation, etc., and religion. And then you see that's eventually built upon in our single comprehensive act, which was the Equality Act of 2010. And that's the piece of legislation that we have now. And I think the Equality Act has made a very impressive stab at a single piece of comprehensive equality legislation. It's tried to bring together competing and sometimes quite disparate strands that come from domestic law, EU law, and the different areas, the different kinds of protected characteristics. I think one of the concerns that I and others raised around the time of the referendum and Brexit was that, in fact, what the Equality Act did for the UK was, in fact, provide us with a fundamental flaw on equality rights. It was a sort of quasi-constitutional approach to equality, which we didn't have in another constitutional setting. And so the Equality Act, I think, in some ways has also served as a form of that kind of constitutional fundamental right, although it isn't a constitutional right, particularly now that we've left the EU, but it's kind of formed that sort of flaw for us. And so I think that sort of gives you a sense of the way in which the comprehensive law has come together. And I think what a good comprehensive piece of legislation can do is it can be both reactive and proactive. So what I mean by that is the reactive model is that when people feel that they have a complaint to bring, they're able to bring their complaint of discrimination, whether it be in housing or employment or whatever, to tribunals and courts. But it also endorses a proactive model, which is very much substantive-based idea of equality. So we see that, for example, in this novel public sector equality duty, which requires the public authorities to consider equality in their decision-making, so to forward plan. Tarun talked about affirmative action, and of course the Equality Act includes positive action provisions. And so that's sort of taking an overview analysis of it. And I think your question around for me was, well, are we there yet? What have we reached substantive equality? And I think the answer is anybody looking at any country in the world right now will say, no, we haven't got there. And it's true of the UK too. I think we have made steps. I can see that we've made some great steps over the 20 years or plus that I've been in practice myself. But I think just stepping back and looking at the last 18 months and 20 months or so of the pandemic, it's very clear that we have failed to reach substantive equality in all sorts of ways. And I also think you have to look at that in the context also of the political debate. There has been a culture war created about equality, and that's incredibly unhelpful to much of the infrastructure, if you like, surrounding a piece of comprehensive equality legislation, which needs to come hand in hand with it. So a couple of quick points if I have time. It might be that I have to come back to them afterwards. I think one of the things I wanted to say about that infrastructure around it is that there are substantive measures within the Equality Act that I think we need to improve. Those, for example, include ideas of positive action. I think that the EU, for example, had, I was almost sort of frozen over the last 10, 15 years. They didn't really know what they meant by positive action. And so I think the impact of that on individual member states like the UK when it was in fact to mean that people were quite frightened of what they could do with positive action. I've noticed in the last 2 or 3 years that I'm being instructed an awful lot to advise on positive action. I think that's a positive change. It's one I think that we can build on. It's one of the very few areas I personally think we might be able to improve on having come out of the EU. there's room for development on that. I think there's room for development on areas of, for example, religious discrimination. Religious discrimination is a classic example of where you have a clash of competing rights. And I think that the European Court of Justice, for example, has been quite regressive in its approach to religious discrimination. And I think that's an area where we've seen English courts actually take quite a substantive view of what equality looks like, but query whether actually the framework for religious discrimination that we have is good enough, whether it really works. But I think the practical point that I really wanted to focus attention on was that there is no use having a set of rights, however brilliantly drafted, if there isn't practical means of enforcement. And I think for me as a practitioner, I think the biggest barrier that we currently face is that there just isn't good enough means of enforcement. So we have a tribunal system that some might say is barely working. We have, backlog of cases. If you've been dismissed because you're pregnant and to do with the pandemic, you might not have a hearing in front of a tribunal till 2023. Discrimination law is incredibly complex. You are meant to be able to go to an employment tribunal without lawyers. In fact, you almost never see discrimination cases without lawyers, because in fact the concepts of this are terribly complex. And what all of that means is that you also need to have really strong enforcement at a national level. We do have an Equality and Human Rights Commission, but I think there are. I'm on their panel. They do a lot of very positive work, but I also think that there are real gaps in the way in which is to do with funding. It's to do with the wider political experience as well, in my view. That means that actually the sort of broader institutional investigatory work that only the National Commission type of body can do, it is not as perhaps profound as it could be, for various reasons, including funding and the culture war. So it's quite clear that to have a functioning piece of substantive equality legislation, you need to back that up. You need to back that up with money. You need to back that up with a commission. You need to back that up with a properly functioning tribunal system, and you have to back it up without a culture war. And just one final thing, which someone might come back to me on questions, is just about judicial training. As a practitioner, I have noticed that there is a difference in the way in which the different strands, the different protected characteristics within the single framework are treated. My view is that it is on balance, and speaking very generally, often harder to prove race claims than it will be in a sex claim, for example. And one of the reasons for that is you need judges and tribunals to be able to take judicial notice. You need them to be able to come with you on some key elements of systemic disadvantage and stereotyping and prejudice. And if you don't have a very level playing field on that bench, you may not get that. I know I'm out of time. I'm going to stop there. But those are just a few of the issues that I think we have to think